Hi, David Campanile here, owner of Campanile Law, located in the state of New Jersey. We do estate planning and probate. As always, if you have questions concerning estate planning or probate, want to set up a strategy session, interested in estate planning or probate, please reach out to me at njestateattorney.com. I'd love to set up a meeting with you and answer any and all of your questions. So today's topic's more about the transfer of real property after the loss of a loved one. So one of the biggest things that people own in the world is their property, is their home. And so we're always concerned about that. We can place the disposition of this in our will. We can put it in a trust. But what happens is, after the passing of someone, we have to worry about the deed. So when handling the deed, it's best to look at the most current deed and see how it's worded. It could be worded as either sole ownership, joint tenancy, without joint tenancy, in trust. But the most common that we face today are joint tenancy with the right of survivorship. So what does this really mean? I'm sorry, everything's blowing up on me today. So when you have the joint tenancy with the right of survivorship, if your other person that co-owns the property with you is still alive, everything passes to that individual by the operation of law. What does this mean? So if Debbie and John both own a house together and they're married and John passes away, Debbie owns the house. Usually a new deed doesn't have to be created. You can have a new deed created, and that would require proof that John has passed away, which would be the death certificate, and a new deed saying that Debbie owns the property. Now we run into a couple other issues when there's sole ownership of the home. With sole ownership, it means that one person owned it. So now that individual's passed away, now the property has to enter the probate process. If it's disposed of in the will, the surrogate court can create a new deed and submit that new deed to the county clerk's office to file the new deed. But if there is no will, now we go through the intestacy laws and we're finding out who the next of kin was. So that could become a little bit of a mess. If you are putting this into a trust, please put your property into the trust before passing away. It gets a little messy. It could get a lot more time consuming and a lot more expensive for everyone if it's not in the trust right away, as it's been named in the trust. So basically, when you're applying to the surrogate court and you need to prove that, hey, I own this property now and my father, my mother passed away, you'd supply to the court, you supply to the county clerk's office a copy of the death certificate along with an affidavit of survivorship saying that you are who you say you are and that this property is yours. You'd give them a copy of the will and they would file that just to put everybody on notice, title companies, creditors, and the state, that you now own this piece of property. It's not a hard process. You can do it yourself. I always recommend at least speaking to an attorney and consulting an attorney beforehand. So transfer of property, not that difficult. I hope you found this video helpful. If you found this video helpful, please like us on Facebook, give us a big like. If you're on YouTube, please subscribe to our YouTube channel and smash the thumbs up button for us. We're putting out content every day regarding estate planning and probate. If you are looking for an estate planning or probate attorney in the state of New Jersey, please reach out to me at njestateattorney.com. I'd love to sit down and speak to you about any questions, comments, concerns concerning either this topic or any other topic that you could think of. As always, I'm David Campanile, owner of Campanile Law, located in the state of New Jersey.